You never know which way it will tilt. So be careful about your body language in court. That's important to know. The second thing I want to talk about is your ability to simplify. Simplicity. Simplicity of thought and simplicity of expression. I cannot give you a better example than Mr. Nani Palkhiwala. I'm sure most of you all in this room have not even seen him. Some of you may have heard of him, some of you may have seen him, but I don't know how many of you had the privilege of working with him. I can tell you, I have worked with him in two very heavy matters, and what completely, I would say I was completely, I couldn't say shell-shocked because that's a very bad expression to use, but I was so pleasantly overwhelmed and surprised when I saw how he would take a problem from us, the juniors, and how he would turn it around and explain it to the judge in language which even a child would understand. To hear Mr. Palkhiwala argue in court, he would get up, he never opened his briefs. You can take it from me, his briefs would come, they would be tied. He would not open a single judgment. It would all be there. In those days, there were only books, no Xeroxes. He didn't have to. He knew it all. He had the law at his fingertips. He had the facts at his fingertips. And he would be able to decipher and degenerate a complete, very, very complex problem of law into something that was so simple. I'll give you one example. We had a case going on of the Mercantile Bank, merger with Hong Kong Bank, before Justice S.K. Desai, one of the most brilliant judges we had. The regional director came and said, sorry, this merger cannot go through. He said, why? Oh, because this company is not liable to be wound up. Which company? The transferor company. So he said, what has got winding up got to do with the scheme or merger? So no, please see the section. Section says a petition for arrangement can lie only if a company is liable to be wound up. So the ROC raised this point. Justice S.K. Desai looked at the section and he said, I think there's something in this point. It says liable to be wound up, but you're not insolvent. There's no ground made out for winding up. How can I? And this has never been raised, never been thought of. And believe it or not, it looks so simple and straightforward, but we couldn't find an answer. And this went on almost the whole day. We were making no progress. And the judge was adamant. In the evening, we went across to Bombay House, met Mr. Palkhiwala, and we said, this is the problem, these are the words, and this is what the judge is saying. So he says, okay, I'll come tomorrow. So we said, there's a fact. No, that's fine. I'll be there tomorrow. Next day he came, and he just explained to the judge why these words liable to be wound up were introduced into the act, and why they had nothing to do with a scheme of arrangement. It only meant that companies who would otherwise or who were capable of being wound up under the Companies Act, not that they ought to be commercially insolvent or any of those, they could come to the company court and seek a merger. We felt like total fools. I'm not joking. I was led by two seniors. I won't name them. They were both experts in their field, both very highly regarded, both had the Companies Act by heart, but we all felt like fools. In 6 minutes, the matter was over. He just went and said, these words have no relevance to the case, and that was it. And there was another case of Killick Nixon, which was like, the volumes were like this, which I had assisted him in. Matter went to Supreme Court. The question was whether a member who has sold his shares can maintain a petition for oppression and mismanagement. The answer given by the other side was, but the transferee is here, so he can maintain it. So we said, no, transferee is not a member, because the shares are not yet transferred to him. The member concerned has sold his shares, but he doesn't have any interest in the shares. So we were like, this is a good thing. And we argued it and we succeeded. The matter went to the Supreme Court. We had a conference with Mr. Palkhiwala. Believe it or not, 10 days before the matter went to the Supreme Court. And it was a huge, voluminous brief. He told us, I want just a 3-page note. I don't want anything more. We couldn't reduce it to 3, we reduced it to 7. We gave it to him. He never got to read it. He never saw it. Mr. Chagla was traveling with him on the flight. He never met him. The next day morning, we tried to have a conference. He was not available. We never met him. We reached the Supreme Court. In the Supreme Court, he was too busy shaking hands with every Tom, Dick and Harry. And then item 1 was our matter. And for 45 minutes, the exposition that he gave to the Companies Act, 10 days after the conference, the only conference which we had had, I can assure you, I had been in that case from day 1, from the drafting of the first petition. But I thought I knew nothing when I heard him expound on the Companies Act the status of a member, the rights of a member, who can complain, what is oppression, what is mismanagement. It was the most beautiful exposition, and in the most simple language that you could ever visualize. So this was Nani Palkiwala, and that is the relevance of simplicity. Since we are talking of Nani, let me read to you something so well said about Mr. Palkiwala to give you an idea of the greatness of his advocacy. And this is what Justice Khanna said about him after he heard him argue the famous decision where the basic structure was, and this is, I'm going to quote, "The heights of eloquence to which Palkiwala had risen has seldom been equaled and never been surpassed in the history of the Supreme Court," unquote. So this gives you an idea when I tell you what I said earlier about Nani and his brilliance, that he got the highest compliment from a great judge of the Supreme Court. A few other points I wanted to touch, which I'll quickly run through now. It is very important to earn the trust of the bar as well as of the bench. Why? Because I consider it to be an investment. It goes to reputation. And having a good reputation or a dependable reputation is very, very important to your success and sometimes even to the success of your client's case. Because very often a matter can turn on not only the facts and the law of the particular case, not only on the basis of the skills of advocacy, but sometimes even on the reputation of the counsel himself. And however much you may feel, how is it relevant? I can tell you with experience, it is very relevant. And it does make a huge difference to a judge as to where that argument is coming from, and more importantly, who is making that argument. But when we talk of trust and reputation, what does it mean? What it means is that every single day that you are in court, you need to earn that trust. And you can only earn that trust and that reputation if you consistently do not bend the facts and do not bend the law. It is better to say, I don't know, rather than fire off and say, this is what the law is. If you are caught out, it's going to go against you for a very, very long time. And let me tell you, judges do discuss about lawyers and how dependable or not they are. As I said, ultimately, they are also human beings. Now, another point I wanted to also talk to you about was the different stages at which you are in your profession. In the beginning, there are no shortcuts. I mean, there are no shortcuts at any stage, but in the beginning, you need to be a master of your brief. You need to know every single page of the brief and possibly looked up every case law that you can think of. Then only you can be of assistance to your senior. But that rule does not necessarily hold good till later on, because as much as a junior you need to spend time on your brief and looking into your papers, as a senior you need to have time away from your brief and away from your papers, because you are only having your thinking cap on and you need to only keep mulling the problem in your head round and round and trying to anticipate and trying to find the best argument that you can make to sell your client's case. So there are different stages at which the advocacy skills operate. And as I said, in the beginning, don't try to be what somebody already has spent 20 years doing. Just do what you're supposed to do, read your brief, master it, look up the law, and be of assistance to your senior. And wait for those 15 or 20 years to come, and you can take it to the next level. Before I end, I want to talk about one important aspect which is developing now, but which Mr. Nariman again has been a past master of, and that's written submissions and list of dates and events. Why do I say it's more relevant in the context of today? It is because judges do not have time to start dictating judgments right away. They very often reserve judgments. They take them home to think about. They've got other matters on the hand. They've got a whole list of cases on that particular day. They've got to run through the board, etc. So very often it becomes extremely crucial that you work hard, and not hard, I would say very, very hard, on two things: list of dates and events. And this, I would say, you work on whether you're going to give it to the judge or you're not going to give it to the judge. Because it will, I can assure you, it will help you no end to put your thoughts in order again, to get a sequence. And you will start seeing things when you put them down in the form of dates and events in a manner which you may not have seen even before. It's very, very important. Coupled with that, written submissions. Equally, please do not ever smuggle in to a written submission something you have not argued without the permission of the court. Please do not try to add cases which were never shown to the court. Please do not try to put in arguments which you never made in open court. Doesn't earn you any brownie points, nor will it help you in your reputation. If at all, it will do damage to your reputation. So be careful if you are required to give submissions. Be very clear that you stick, however much your attorney, your client, whoever wants to push you, let them do it. I will not be a party to it. I can only tell you from experience, I have worked in several matters with seniors like Mr. Nariman, and I cannot tell you the amount of effort, the number of corrections, re-corrections, re-corrections, and whatever you want to take it to level of corrections that Mr. Nariman used to make only on his list of dates and events. I have seen it with my own eyes, and I used to often feel, what is this man doing? I mean, is he crazy? I mean, he's just done this yesterday and today he wants to redo the whole thing. But I tell you, when that piece of paper is finally presented, the judge doesn't need to open a single piece of paper. He doesn't need to look at the record. It will have everything that one could ask for from Mr. Nariman's side, whether it be the facts, whether it be the law, without twisting anything in a manner which would be incorrect. So this is the importance, and entire matters have been won or lost on the basis of the correct reproduction of the list of dates and events. So that is an important skill. It's a skill set by itself. When you talk of advocacy and the multifarious skill sets that I mentioned, this is also one of the skill sets which you can develop and which will stand you in good stead. And last but not the least, my final advice to all of you budding lawyers, or many of you who are budding, the advice I can only give you is, you will learn the art of advocacy only if you observe, observe, and observe. That's what you should be doing. When you go to court and you see others arguing, you will learn what to argue, and more importantly, you will learn what not to do. With that, I would like to end the talk. Thank you very, very much.